There we
Hi, everybody. Thanks again for joining us. Today we have a special guest speaker. Her name is Debra Scheufler. She's a medical-based attorney in California. And just one thing that you understand, I get a lot of calls on a lot of my medical practice listings. And there's a lot of private equity out there. There's a lot of money out there and a lot of investors that are looking to buy businesses. And unfortunately, I have to turn them away if they don't understand the laws regarding corporate practice of medicine in California. So today we're going to have Debra talk about how private equity, as well as anyone who's not a medical professional, can own a medical practice in California and do it without violating any laws. So, Debra, maybe you can kind of give us an intro about yourself and go right into how people can do this.
Sure. Thank you, Jerry, and thank you everybody for watching this video. I have been practicing in California for 28 years, and I've been involved with healthcare law for about, I don't know, 18 of those years, and specifically in the med spa industry for about the last 15 years. And California has some very unique laws, and it is a corporate practice of medicine state. And this is the challenge. The question is, how does private equity and how do lay people get into the healthcare business in corporate practice medicine or CPOM states? And it's very common. This is how, so we're going to talk about the MSO PC model, and I have some slides to bring up in a few minutes to talk about that. But this is how big hospitals work. You know, when you hear about shareholders in big hospitals, they can do this because there's a lay company, in other words, not a medical entity, that is in charge of the business and administrative side of the industry of the structure. And this can become a publicly traded company. So it's definitely not a medical practice if it's a publicly traded company. So I set that out as an example because that is a very high revenue, large organization that utilizes this structure. So let me just do a screen share here and pull up this this PowerPoint and see if I can get it in the right format. There we go. So we're going to talk about using an MSO in CPOM states. Like we said, how private equity can participate in the healthcare industry. There's a lot of revenue in this industry, as we know, and there's a lot of private equity wanting to get involved in it. So we'll talk about how we can do that. But first, as I was telling Jerry, whenever I have a platform, I like to talk about one of my most favorite things, and that is wolves. This is a picture of a Mexican gray wolf. This is a critically endangered species. And there is an SSP, a species survival program, an international species survival plan for this gorgeous animal. If you want to know more about this, you can Google, the California Wolf Center. And if you want to know how important wolves are to ecosystems, there's a YouTube video. It's about a 15-minute movie called How Wolves Change Rivers. So that's your wolf information for today. So let's get into the legal part. Of course, I have to give this disclaimer that nothing contained in this presentation is intended to be or should be taken as legal or tax advice. The information contained herein is generally informative in nature and does not necessarily apply to any specific situation or legal need. And attendance at this presentation does not create an attorney-client relationship nor any expectation of confidentiality regarding anything you may disclose to the presenter. So let's get right into it. What is corporate practice of medicine? So the corporate practice of medicine is a prohibition against practice of medicine by a lay entity. And this is the model in many states, California being the one that I practice in. And this is, one of the most restrictive models. There are other states like Arizona that have changed their laws such that lay people and lay entities can own a medical practice and employ a physician. In California, medical services must be provided by a medical practice, and that medical practice can be a sole proprietor physician. In other words, a doctor hanging up their shingle and practicing medicine. a partnership of physicians, and or a professional medical corporation. This is the entity structure that is most often used in medical practices in California for a variety of reasons. But professional medical corporation. And in some states, you may see PLLC, that's a professional limited liability company. We don't have that in California. The only entity that can be used to practice medicine is a professional corporation or a PC. The PC must be minimum 51% owned by a physician. Don't get too excited because that other 49% must be owned by an allied licensee. And that is, there's a long list in the corporations code of allied licensees, which include RNs, NPs, PAs, chiropractors, naturopathic doctors, dentists, and a bunch of other professionals, medically related licensees that can own that 49%. Oftentimes, that 49% owner will also be the MSO owner. In that case, we're not talking about lay people. In this case, we are addressing how lay people can do it. So let's move on to the next slide. The answer is to create another entity, can be an LLC or a corporation. And I highly recommend that you get tax advice on that, because depending on where you're domiciled and what revenue stream you're looking at, and how many parties are involved in the MSO structure, how many equity holders there are. Oh, I know, I have a volume thing. I can turn it down. I just got a new phone system and I don't understand it totally yet. And I was just looking at it ringing going, how am I going to shut that thing up? The volume button, I'm a genius. At any rate, my point is that there is no entities du jour. And I do not recommend that people run out and just file their own LLC or corporation, or go through one of the filing services like Swift filing or LZ or any of those, because they are not giving you legal advice. And there are a lot of things to consider when setting up an entity. It is an in-depth tax and liability analysis that should be done. And it's going to be based on where the revenue is coming from, what the revenue ROI expectation is of the participants, et cetera, et cetera, et cetera. The joke is the answer to every legal question is it depends. And this is a big it depends question. What entity should I use for this? So the entity may be owned by lay people, which is what we're addressing here. The purpose of the entity on paper is to provide management and administrative services to the practice, the PC, right? It also typically controls the leased premises, owns the IP, owns all the FF&E, that's furniture, fixtures, and equipment, so all the hard assets. And these are all licensed to the practice, along with providing those admin and management services to the PC. Now, this structure is designed with 4 objectives in mind. The first one is compliance, because without those licensees, the physician, the nurses, the other providers that are working in the practice, without them, we don't have an industry, right? So we want to keep their licenses as our first objective, protecting those licenses. So we want to be compliant. The second objective is control, and that is giving the MSO participants, whether they're lay people or allied licensees, as much control of the structure as we possibly can. The third objective is tax efficiency. And this is where, we get into this tax analysis question and setting up the entity, but we want to help people receive the revenue and utilize the revenue in the most tax efficient ways possible. And that is, again, an in-depth analysis and conversation. And the fourth objective is creating an acquisition target. So if the PC, the practice, is 51 to 100% owned by a physician, and all the revenue is coming into the practice, how do we get that revenue to the MSO, which is owned by the private equity people? How do they receive the benefits of that revenue, and how does that become their acquisition target? Well, this is how we do it, by the structure that's laid out here. The MSO is going to have control of the leasehold estate. It'll be the tenant on the lease. It will own all the hard assets, right? All the stuff that you don't either use and throw away or put in or on a patient and they walk out the door with it. That includes computers and tablets and treatment chairs and art on the walls. And the most expensive asset that these practices have are the lasers, the machines, right? So we want to purchase all those through the MSO. The MSO will own the IP. And we know in business that IP is worth a lot, right? That's where your goodwill is. The name of the practice, your digital assets, website, your review sites, your social media sites. Those are going to all be owned by the MSO, and all this is licensed to the practice through the management services agreement. Sometimes they're called management agreements. Sometimes they're called facilities and management agreements. Essentially, that's the agreement that allows the practice to have a legal right to use these things. So now we've got control, we've satisfied that objective, and we've got the compliance objective satisfied. And then for licensing those things to the practice and providing those admin and management services, the practice pays the MSO a huge fee. What I normally do is
Debra, could I just clarify
sure.
a couple of things? So
Yeah,
the
yeah.
MSO stands for Management
Yeah, I'm
Services
sorry.
Organization,
Yeah.
right?
Yes,
Okay,
yes.
good.
I'm
So
sorry. I
MSO.
forgot. Yeah, I forgot to explain that. It stands for Management Services Organization. We get so used to these acronyms that we forget that
Yes.
not everybody knows what that is. Yes, go ahead. What else? Anything
And
else?
then the IP is intellectual property.
The IP is intellectual
IP
property.
is
And that's going to include the trade
okay,
name,
good.
the name of the practice, the URL, the website itself, the social media accounts, the review accounts, and any logos or other intellectual property that the practice might utilize in the course and scope of its business. Good?
Thank you.
Good. Okay, good. Yeah, thank
Perfect.
you.
Thank you.
Thank you for slowing me down there. So for providing all these things to the professional corporation, I say PC, that's the medical practice, right? We do a profit sweep. In most cases, in most of the entities that I set up, the doctor knows that they are not going to be an equity participant. This is all upfront. Everybody knows this from the very beginning. The doctor knows that he or she, although they may own the practice, they're not going to be in the practice every day working. They're going to be providing medical director services, meaning they are a supervising physician. And by the way, as an aside, this doctor can be an MD or a DO, and that's it. No ND, no DDS, no DC. In other words, no chiropractor, no dentist, no naturopath. It must be an osteopathic or a medical doctor, and they have separate boards, but they're held at the same
I know
level.
you
Go ahead.
I know you from my understanding years ago, dentists could own a medical practice. Was that
No, they
one?
can own a dental practice, but not they can be a 49% owner of a medical practice, but they can't be that 51 to 100% owner, but they can own a dental corporation, which is a different thing altogether.
Okay.
There's a lot of action in buying and selling dental practices. That's how I started in healthcare, was in dental practice. Yeah. So with the understanding that that doctor knows that he or she is going to get his or her medical director fee, and that's it. And they're going to be a supervising physician. The rest of the revenue that is not needed for ongoing operations is swept to the MSO as a fee for licensing these assets and providing these management and administrative services. Now, our management services agreement lays all this out in great detail, and it's malleable to a certain extent. And we articulate the management fee such that it's a little nebulous, so that it can change from month to month. And we have certain ways that we can, state that. One thing that's really risky to do is to state a percentage payment that can be deemed a kickback. Some people will contract around that, and it can be done. I like to avoid that altogether because I don't ever want to get anybody in that kickback range. So that's the basic structure of how it's set up. So let's go on to the role of the doctor. So when a client comes to me and they're getting into this industry, one of the first questions I ask them is, I ask them what license they have, and if it's none, that's fine. We move on to this structure, what their experience in the industry is, where they're located, and who the doctor is that they are looking at working with. I have over 250 healthcare clients throughout California, from Chula Vista up to Nevada City. And I know a lot of doctors, and there are doctors in almost every county who will serve as this medical director position for these clinics. So a lot of times I'll introduce people to a doctor. It's not something that I charge for or anything like that. It's just that I happen to know a lot of people. The doctor has to have that ownership in the practice. They may or may not treat patients. You need to know when you're applying for the insurance whether they're treating patients, because it's coverage for a treating physician is different than coverage for a supervising physician. So if that changes during the course and scope of operation, then you need to let the carrier know. So what constitutes supervision? Well, the medical board has a very nebulous definition of supervision. And in law school, we read these landmark cases, and there's this old case about pornography, and I can't remember the justice who made this statement, but he said, and it was, in the 1900s, right? He said, I can't describe it in detail, but I know what it is when I see it. And that's kind of the same as the medical board's view of supervision. It's not in detail described, but they know you're either supervising or you're not, okay? And, there's a lot of companies out there who will provide this like turnkey, own your own med spa system, and they'll hook people up with a doctor who might be licensed in California but lives in Hawaii or North Carolina. I've seen this exact thing. The medical board is not going to deem that supervision when the doctor lives out of state. So I have come up with some indices of supervision that I require my clients to do. One of them is, and I didn't put that up here, but one of them is they need to walk their little feet into the door of the clinic once a month. Now, the code says that for RN, it's different for RNs. RNs require a higher level of supervision and that's registered nurses, than nurse practitioners or physician's assistants. These are the three categories of allied licensees that are typically treating patients in these practices. First of all, physicians are limited to the number of nurse practitioners and physician's assistants they can supervise. Right now, I believe it's 4 of each. Nurses are unlimited, but nurses require a higher level of supervision, right? So when physicians sign off on charts, which is one of the items here, the third one down, the number of charts they sign off on is going to be dependent on the license that licensee holds. In the code, it says that there's no minimum, there used to be a minimum requirement on charts that need to be countersigned by the physician. There's no minimum requirement anymore, but for NPs and PAs, I advise my clients to still have that physician countersign 10% of those charts, because we don't want to be doing the bare minimum under the law. It is very common for the Department of Consumer Affairs to investigate med spas for a number of reasons. Just happens to be so. And I defend a fair number of these investigations. And even when they elevate to the level of an accusation, I defend them. So I know what can go wrong. And when I set my clients up, I set them up with that in mind so that we can avoid these pitfalls and keep everybody out of trouble. So the physician must visit the clinic once a month, must be the final decider on all new hires. I have a document set whereby this is all documented, even though the boots on the ground person, which could even be the lay person who's the private equity owner of the MSO, they might do the advertising for the employees, they might do the initial interview process, they might do the initial vetting. The doctor must be the final decider because he or she is the boss of all medical services and everything related to medical services. The physician must be the final decider on all new procedures, and we have a way to document all this. The physician must review and countersign charts. Again, the number of charts that need to be countersigned is going to be up to the physician, or up to dependent upon the licenses held by the providers in the practice. There must be policies and procedures on site, a hard copy. So this is what a typical policy and procedure manual looks like. It's huge. And you must have a hard copy on site. We have a book that we produce here. I have one room that's 100% dedicated to producing, updating, revising, and creating this book. There are lots of places you can get a policy and procedure manual. Of course, I love ours the best. And we have a very discounted price for this book for our clients. It includes an HR section, general policies and procedures, management of adverse events, DEA, HIPAA, OSHA, and then consent forms for every procedure, how to do it, and then the pre and post care. And those are the things that the board wants to see on site. It has to be countersigned. It has to be signed off on by all providers and the doctor annually. And you have to keep those sheets, those signature pages for 7 years, because that's how long the board has to come after a practice for something that goes wrong. So that's shocking to people. And I've had people get in trouble for not having those signature pages from when an incident occurred. And there's a standing order. The standing order is, how a medication is dosed, because an RN, a registered nurse, cannot decide how much of a neuromodulator to inject into a patient. And you have to have that standing order that says, 30 to 60 units of Botox per area. And then the nurse can, look at the level of intensity of the situation and, work within that range. So these are the things that must be in place for supervision. So don't forget that visiting the clinic. I require my doctors to visit the clinics. And for this reason, they have to be relatively geographically convenient. Most of these doctors have practices, ongoing practices. Many of them are plastic surgeons. And one of the reasons that they do this medical director gig is because they can get referrals for cases. Medical aesthetics can only do so much for a patient. And at some point they may want something, a more extreme procedure to make a more dramatic change to their appearance, in which case they can see a plastic surgeon. There are also strict rules about referring patients from one practice to another, and we can provide documentation to make sure that that's all covered. The patient has to consent that the physician has ownership in both practices and that they have a choice to go anywhere they want to. And as long as they have that, they can pick that physician since they're already, working with him or her. Now, I also wanted to talk about medical director fee. This is a question I get a lot, and that is, what is the monthly medical director fee for these physicians? It cannot be a percentage. That would be deemed a kickback. Providers in California can get paid a percentage only of services that they perform. So a doctor or a nurse or a PA or a nurse practitioner can get paid a percentage of net or gross for services that they actually perform on a patient. And we do write employment agreements like that. They can get paid hourly, they can get paid percentage, they can get paid a combination. Everybody but physicians must be W-2 employees in California. This is another thing that shocks a lot of people that come in from out of state. Our labor code changed in 2018. And the restrictions on who could be an independent contractor got very narrow. And suffice it to say that allied life, anyone who needs to be supervised has to be a W-2 employee. So physicians can be independent contractors. They can be 1099, but when the physician is the owner of the practice, and I'm kind of going on a tangent here, but it's just giving you an idea of how complex these laws are. If a physician has ownership in the practice, he or she has to be a W-2 employee, or that practice can 1099 another practice that he or she has, and then that physician can W-2 themselves out of that practice. They would get that shareholder distribution W-2 split. This is a tax thing. This is an individualized conversation that we have with people. Medical director fees in California range from about $1,000 a month to $5,000 a month, depending on the geographical location, cost of living, what's the price point for that region, and, the volume of the practice. A high-end, busy practice in Beverly Hills or Marin is going to be more in the $3,000 to $5,000 range. Inland Empire is different, San Diego, Orange County, there's all different ranges, but that's the big picture in that, and people should be prepared for that. And based on, this definition of these activities that they need to engage in to supervise, they actually have to do something more than hang their license up on the wall. We have a compliance package that we provide for new clients, and it includes 3 videos, compliance videos, one on AB 890, which addresses nurse practitioners, one just on general, pitfalls and how to stay out of trouble, and one specifically on marketing and Instagram and websites and how to make sure that the practice is compliant and really shows the public that that doctor is in charge. There's a physician there, he or she is supervising, and down to, I require my clients to have a picture of that physician. When you walk in the door, wherever the patient intake area is, there should be a picture of that doctor up there, so that anybody looking knows there's a doctor there. So those are some
That's a
extra
good point.
compliance tips. Yeah, it's really important. And like I said, I've defended enough of these accusations and investigations to know that these things will save people's tails in an investigation. So here's a little flow chart that, very rudimentarily articulates what I've just described. I have a more in-depth flow chart that I go through with my clients, but this is just a good, accessible description of the structure for people who, want to use it as a resource. For anyone getting a copy of this video, you can study this and kind of, it gives you an idea of how the whole structure works. So that's what I have to say about that, Jerry. Do you have any questions, or are there any questions that your clients ask that commonly that I can help with?
Actually, can you walk us through your flow chart here real quick? So it starts with the patient fees.
Sure. Yeah. Right. Figured out yourself. So yeah. So as I said, oops, let me go back. I'm used to highlighting this when I go through it. So as I said, medical services have to be provided by a medical practice. That's in our world, it's going to be a professional corporation. Patients must obtain those services from the medical practice and must pay the patient fees into that medical practice. The practice will buy all its product, it pays for its operating expenses, anything that it needs to keep the doors open. It's going to pay its employees, and it's going to pay, the big one for our conversation is that management fee. So that management fee then comes into the MSO, the Management Services Organization. This is the entity that's going to be owned by your private equity client who doesn't have any kind of medical license. And again, it is for management, admin, licensing the intellectual property, licensing use of the furniture, fixtures, and equipment, and providing that clinic space for the practice to operate in. Because we want to make sure the company owned by these private equity lay people controls the major assets, the clinic space, the hard assets, the intellectual property, and gets the bulk of the revenue. So we do this profit sweep where, we have this revenue coming into the PC, and everything we don't need to operate, we do that profit sweep as a management fee over to the Management Services Organization. And then that company is going to pay the rent. It's going to buy the stuff, the pictures on the walls, the lasers, the computers, the tablets, the whatever, the treatment chairs, whatever they're going to use. And then the owners pay themselves per specific tax guidance that they're going to get from whatever professionals that they're working with. And this structure satisfies our 4 objectives up here, which are compliance, right? We have a compliant medical corporation that the patients are paying and that provides medical services to the patients. Control, we've given the MSO control of the leasehold estate, the hard assets, the intellectual property, and the receipt of the revenue. Tax savings, we have these conversations individually with clients because everybody's in a different situation here, right? So we teach people how to pay themselves in the most tax advantageous way. We have many tax professionals that we work with and refer to when when people really start to grow and need more creative solutions to, their revenue and tax issues. And then creating that acquisition target. The MSO now is the recipient of the bulk of the revenue, controls the lease, and anyone who's ever bought a business knows, Jerry, having that lease is really important because you want continuity in that business. Even if the business is grossing $5 million a year, which is not unusual for a medium to small med spa, as you know, if they have to move, there's going to be some attrition. There's already going to be some attrition in the transfer if that's not handled right. You and I together, or when I work with, whomever, whoever the client works with, the lawyer and the broker together work to help make that transition as seamless and painless as possible. And we teach people how to do that in such a way that attrition is reduced. I got myself confused there. I lost myself. It owns all the stuff, and it owns all the intellectual property, and that creates the assets that are sold in an asset sale. And most of these sales, I'm sure in your world, and most of them in my world, are asset sales, because
Right.
the stock sales, that's a whole other world. You need a special license for that. There's extra risk associated with it. And one thing that people should know is that patient charts cannot be sold. Patient charts, just like legal clients, cannot be sold. Patient charts belong to the patient. Like my files belong to the client. I may be the custodian of them while I'm working with the client, but at the termination of representation, they have received all their documents. We do it all digitally these days, but there are some cases where we keep it forever. The physician is responsible for maintaining those patient charts. The patient can request those at any time and take them to any physician they want. So now the goodwill, though, associated with the practice, how it's presented to the public, the intellectual property, the name, right? The logo, the brand that's been created, which is mostly the work of the management company creating that brand, that's what gets sold. And just FYI, now that we're looking at this, I'm so glad you asked me to explain this in more detail because it brings up a lot of things that I didn't mention. People may ask, they wonder like, oh, what if my relationship goes sideways with the physician, especially when the MSO people are lay people and the physician owns 100% of the practice. We set these structures up so that this PC is pretty much interchangeable. We can put anybody in that role as long as they know how to do all the services that are being provided and they supervise. They're geographically convenient and they know how to do they comply with the supervisory requirements. We can do this very quickly. I have done it in 2 days in an emergency. I've had everything you can imagine happen. I've had physicians die. I've had physicians file personal bankruptcy, and the bankruptcy trustee comes in and tries to take the stock of the PC to sell to pay the assets of the physician. It took 3 months and 3 lawyers and several $1,000s for me to educate that trustee to the fact that this practice is worthless because it doesn't make any money and it doesn't own anything, right? So we can either do a stock transfer from one physician to another, or we can just bring in a completely new PC. And we also have ways to protect the name in situations like this. So the physician doesn't walk away, even though they've signed an agreement that says the MSO has control of that name. We set people up for success so that if that physician does get a little squirrely on us, which I've seen, we can keep the control of the name in the hands of the MSO. So that's the flow chart, and those are just some extra little things
Excellent.
that we've run
Thank you.
in.
So let me ask you this, Deborah, and I don't know if I mentioned this to you, but I also am a partner in a bookkeeping firm, especially for med spas.
Oh,
And
wonderful.
so obviously so we get, so we're doing P&Ls for both the MSO and the PC, right? So many times the MSO is paying the operating expenses and employees rather than the PC.
Well,
Now, is
that's,
that a violation of any laws, or how would that
yes,
be looked at?
yes, that is a no. The medical providers, people who touch patients and treat patients, must be employees of the PC. And it is a violation and could be deemed corporate practice of medicine, unlawful practice of medicine, unsupervised practice of medicine, and other things that are violations of the California Business and Professions Code. I have been in investigative interviews where the investigator asked to see that that nurse being investigated got a W-2 check from that PC. So yes, they do look at that. And the revenue flow is critical here to maintain a compliant structure. That's why I provide this flow chart and other derivations of it to clients so they really understand what has to happen here. Now, if they're an admin person, they can be paid by the MSO. Probably not the best idea from a bookkeeping perspective, because if you really want to keep all the operating expenses under one roof, I would keep it over here. The owners of the MSO sometimes get W-2 plus shareholder distribution in certain structures. That's very common, especially in the beginning when revenues are just building. But so there would be a separate payroll account over here because of the reasonable salary requirement under the IRC, Internal Revenue Code. But yeah, those providers must be W-2 employees over here. The thing I see more commonly is people try to make them 1099 independent contractors. That is a huge violation of AB5, and it can be very expensive to the employer on this side. I have a doctor right now who is paying off $175,000 judgment and penalty for mischaracterizing employees as independent contractors. The worker doesn't get in trouble for it, but the principal does, the employer does.
Got it. Now, what about the operating expenses? You're saying that has to be paid for the PC. So that's any type of well, of course, all the supplies, right? The medical supplies in inventory.
Supplies, yeah. And the services that serve the PC. So if you have a good faith exam service, because a good faith exam, as we know, has to be conducted for every new patient and annually for repeat patients. And this must be done by a physician, a nurse practitioner, or a physician's assistant. And usually the medical directors aren't going to do this because it's too onerous for the amount that they're earning as a supervising physician. And it also may take them out of that supervisory role and impact malpractice coverage. So if there's no nurse practitioner or physician assistant on staff, there are services that can provide this good faith exam, or GFE, as we say, service, that are compliant, and they can be paid per good faith exam. Where was I going with that? I forgot. Oh, services. So your GFE service, your EMR or EHR, which your electronic medical records or electronic health record system. This is what is used to receive and contain the patient charts. That's software that's used. Your point of sale system, any services that specifically serve that corporation, the percentage of the bookkeeping services that go to that corporation, the tax preparation, the payroll account, the services, the legal, right? Don't leave me out, that serve that practice are going to be paid by the practice. These are the expenses of the practice. The management services organization is going to have its own set of expenses besides rent and FF&E. It's also going to have bookkeeping, tax, It may have some software, it may have marketing, it can pay marketing. Um, and it has its own share of the legal, and then paying the owners who are doing the actual management portion.
Okay. Wow. So that sounds like there's a lot of moving parts here. So
A lot of moving parts, a confluence
yeah.
of many areas of law that come together to govern these practices. And, we haven't even talked about, trademark law, which is one of the conversations we have with people, because one of the first things that people do when they get excited about a new business is they come up with a name. Well, there's a lot of rules about these names, right? And the standard for confusion in the trademark world is confusingly similar. So, or the standard for a violation, infringement, is confusingly similar. So, for instance,
Mm,
if my med spa is called Glow Beauty, I'm just going to make up a name, Glow Beauty, and somebody comes along and they want to open a med spa and it's San Diego Glow Beauty, right? That is, in trademark world, going to be deemed confusingly similar, and it's going to be an infringement on my trade name. Whether it's registered or not, I have common law rights to that name if I'm the first one to use it. And I can get an injunction against that junior infringing user to cease and desist the use of that name. So that's why we vet names. That's the very first thing we do with clients, is we vet those names, because we don't want to spend thousands of dollars on marketing up a brand and get that, it's usually a letter, not a knock on the door, but get that cease and desist letter 6 months later, and now you've got to spend, $5,000-$10,000 to rebrand.
right. Right.
So
Got it.
that's another piece that, that's just an extra service that we get involved in to help people.
Great.
So
Okay. Well, thank you. There's so much information here. Obviously, this is just, I know, the tip of the iceberg. So
it
if
is.
if a client wanted to get more information, Deborah, how would they get hold of you?
So my website is schefflerlaw.com. That's SCA. I should have had a slide with my email address on it. SCHEUFLERLAW.com. Our phone number is 619-377-6523. People can call me, email me at Debra@schefflerlaw.com. Send up a smoke signal, howl like a wolf. And
Okay,
speaking
excellent.
of wolves, this brings us to the end of my presentation. I always show this cute little wolf picture, because see that little dark spot on the tail of the wolf there? That is the
Uh-huh.
pineal gland, and that is an extra scent gland that wolves had. And it's always marked by
Wow.
that little dark spot. And so when people are looking at, canines, and they're wondering if they have any wolf in them, that's one thing to look for besides skinny legs and fluffy ears and gold eyes, is that little dark spot on their booty.
Okay, got it. Well, that was a good education on wolves as well. So thank you for that.
Thank you so much,
All right.
Jerry. Yeah, it's a pleasure.
Yes, it was a pleasure having you. Thank
Yeah.
you. And again, guys, if you're thinking of buying a medical spa or a medical practice in California, now you've got a basic idea of what you need to be thinking about. And then, of course, again, contact Deborah for more information. All right, Deborah, thank you for your time today, and we appreciate your input.
Thank you so much, Jerry. I'll talk to you soon.
All right, take care.